This is Bart Peterson, and you are listening to the FCPA Compliance Report on the Compliance Podcast Network.
This is Greg Gilchrist, and you are listening to the FCPA Compliance Report on the Compliance Podcast Network.
This is Dan DeMarco, and you are listening to the FCPA Compliance Report on the Compliance Podcast Network.
In this episode of the FCPA Report, I visit with Don Stern. Don is a managing director at Affiliated Monitors, and he's a former U.S. attorney for the state of Massachusetts. We talk about the role of the U.S. attorney in the Department of Justice, how the U.S. attorneys across the country relate back to Main Justice, and how cases are handled in a variety of situations. It's a fascinating exploration of the U.S. Attorney's Office. Hello, everyone. This is Tom Fox, back for another episode, and I have back with me Don Stern, Managing Director at Affiliated Monitors. Don was the U.S. Attorney for Massachusetts at one point in his career, so I asked him if he might come on and explain the structure of U.S. attorneys across the country, how they relate to Main Justice in Washington, and generally explain to the layman what it means to be a U.S. attorney. So, Don, first of all, thank you for taking the time to visit with me, and welcome back.
Thank you very much, Tom. Good to be here.
Don, can you describe for us the structure literally across the country of the Department of Justice?
Sure. The Department of Justice, obviously, is the main office is centered in Washington, and actually within the department it's referred to as, quote, Main Justice, because although some of the functions are located in Washington, there are 93 U.S. attorneys scattered all across the country who have significant authority and discretion to bring both civil and criminal cases in their respective jurisdictions. So it's a mixture. It's in some ways, Tom, a unique animal in federal governmental organizations, because while things are, as we'll talk about in a minute, while things are to some extent centralized, they're also decentralized in a way that really doesn't happen very often in the federal government. And you've got representatives of the Department of Justice, U.S. attorneys and their offices, which represent federal interests, but also try to gear their priorities and their activities to local needs.
Could you maybe now, Don, focus on the role of a U.S. attorney, or at least the role when you held that position?
Well, it hasn't really changed much. And one of the interesting things is the U.S. attorneys' positions, U.S. attorneys themselves are appointed by the president, confirmed by the Senate. So they're presidential appointments, but they now serve, if you will, under the umbrella of the Department of Justice and the Attorney General of the United States. And all criminal cases in various federal districts have to be brought. This is probably an overgeneralization, but it's about 95 or 90% true, have to be brought by U.S. attorneys. So if the FBI, DEA, ATF, any federal agency investigates a case and they seek to have that case prosecuted criminally, they really need the U.S. attorney to approve the prosecution and to move it forward. On the civil side, it's similar. The U.S. Attorney's offices represent the United States in their civil capacity. There, the authority is a little bit more diffuse because you have individual instances where federal agencies have the authority to bring civil cases themselves. The SEC is a classic example. The Federal Trade Commission is another example where Congress has delegated to those agencies the authority to bring civil cases on behalf of the agencies. That's really not the case on the criminal side. The Department of Justice is pretty much the only game in town.
Don, what's the structure of the U.S. Attorney's Office itself? Did you have attorneys working under you, and how did that process work?
Well, yes, you have attorneys. And when I was there, we had a little bit over 100. I had a little bit over 100 assistant U.S. attorneys working under my general supervision. Some of the larger offices, L.A., Houston, Chicago, New York, and of course, New York has several U.S. attorneys' offices. They could actually have several hundred assistant U.S. attorneys working in those offices. And typically, although it varies from office to office, typically they're divided up into a civil side and a criminal side. And then on the criminal side, they are often broken into particular areas. For example, when I was U.S. attorney, we had a drug unit, We had an organized crime unit. We had people who focused specifically on healthcare fraud. We had a public corruption unit. So you tend to you break the office into various specialized groups with some overlap between the groups.
Don, if I could now turn to policy, and certainly in the anti-corruption world, we've had policy pronouncements by either Deputy Attorney General Sally Yates had one, Brian Benchikowski had one. But could you describe how policy is set, and then how is it carried out in the 93 U.S. attorneys' offices across the country?
Well, there are really two different types of policies, Tom. The first are policies which govern how cases are to be brought, what the standards are, what the threshold for bringing a case, how immunity is to be granted or not granted in a particular case. And those are usually reflected in what's called the U.S. Attorney's Manual. And the so-called litigating divisions of the Department of Justice also look to the U.S. Attorney's Manual. And those policies are really set by the Attorney General with a lot of input over the years from what's called the Attorney General's Advisory Committee, which is a representative body with rotating membership that meets usually once a month and discusses policy that might be applicable to the U.S. Attorney's offices. I actually was chairman of that group for a couple of years when I was U.S. Attorney, and the Attorney General typically look to that to what's called the AGAC for some advice. But in the end, it's up to the Attorney General to decide what goes into the U.S. Attorney's Manual. The other kind of policy is what are the substantive priorities of the Department of Justice and the various U.S. attorneys. Do we want to focus on drugs? Do we want to focus on the opioid crisis? Do we want to focus on child pornography, immigration issues, telemarketing, cybercrime, et cetera? And there again, those are general policies that are set by the Attorney General, and they vary from administration to administration. But there's also within that umbrella a fair amount of flexibility and discretion afforded to individual U.S. attorneys' offices to tailor those priorities, those national priorities, to the needs and requirements of their particular district.
Don, I know one question that I have always had is, does a U.S. attorney, or how do they decide to open an investigation? Does an investigative agency such as the FBI come to you with evidence? Is it more of a policy? I guess now the PPP fraud and PPE fraud has been identified as a major area of investigation. But how would you, as a U.S. attorney, decide to either open an investigation or move forward with a prosecution?
Yeah, it's a good question, and one that over the years I've been asked a lot. The short answer is it varies, and there's no one size fits all. So just to put it into context, Tom, the traditional model of prosecution, even federal prosecution or across the country, was the investigative agency does the investigation by itself, interviews witnesses, et cetera, bundles up all the evidence and presents it to the U.S. Attorney's Office for the U.S. Attorney's decision about whether to go forward or not. And that model still applies in what I would call sort of simple cases. Somebody goes into a bank, a federally insured bank, with a note and robs the bank, and the FBI is waiting outside. They arrest the person. That case is pretty cut and dried, and that case might be presented to the U.S. Attorney's Office for federal prosecution. But that model over the years, for good reason, has changed. And what you see now, particularly in sophisticated cases and in complex cases, is basically a marriage between the investigative agencies and the resources and judgment and skill of the assistant U.S. attorneys involved in the case. So, and that's in part, and it's really that partnership which really often builds the best cases. Now, some of that is because the toolkit available to federal agencies, FBI, DEA, you name it, does not include, for example, the authority to use the grand jury. So if you're going to use the grand jury to investigate a case, you need the U.S. Attorney's Office because they are the only lawyers that can make presentations to the grand jury. If you want a wiretap, the FBI doesn't have the authority to go to a judge and get a wiretap. You need the U.S. Attorney's Office to do that, or Main Justice, some lawyer in Main Justice. If you want to, grant immunity to a witness, if, let's say, you're working up the chain of command in an organized crime case, so you might want to grant immunity to some lower-level member of organized crime in an effort to kind of reach up the food chain to get at the bosses. The FBI doesn't have the authority to grant immunity. Only the U.S. Attorney's Office or the Department of Justice does. So that's a long-winded way of saying the best cases, the most complicated cases, are almost always done in partnerships of investigative agencies and the prosecutors working together.
Don, if there's a prosecution involving a Main Justice investigation, but it's done in one of the U.S. Attorney's offices, say here in Houston, are the trial lawyers from Main Justice, are the trial lawyers from the local U.S. Attorney's office? Is it both, or is it really just a individual case-by-case basis?
Well, generally it's both. I think, again, there are certain subject areas that are really carved out as kind of the mainstays of Main Justice. The classic example might be, let's say, an antitrust case, which requires considerable expertise and specialization. Very few U.S. attorneys' offices are going to have the ongoing expertise to really prosecute an antitrust case. And so Main Justice will come in and do that. But here again, it's the local U.S. attorney's offices that know the judges, they know the juries, they know the environment, they know, the local custom and practice. And so even there, I remember we had a major antitrust case that was being tried during my tenure, and it was being tried largely by the lawyers out of the antitrust division in Washington. But I had somebody in my office with some expertise in the area basically serve as local counsel. So it's rare that the U.S. attorney's offices are not involved in each and every case. And often, let's say in an FCPA case, there could well be and likely would be lawyers from the fraud section involved. But here again, they would probably work in partnership with an assistant, an AUSA in that respective office, whether it's Houston, Chicago, San Francisco, Boston, you name it. And usually there are very good relationships between U.S. attorneys' offices and Main Justice. So those things, if they're done right, will work seamlessly.
Don, what's the structure or situation when you have a major prosecution around a task force? And the example I'm familiar with is the Enron task force from the early 2000s here in Houston, but it could be, 2020, it could be PPP task force. How is that structured?
Well, usually that reflects priorities of the Attorney General and of the Department of Justice. So often it's in response to a particular problem. So there might be, as you said, an Enron task force was in response to a particular issue. You may remember, Tom, in the early 90s, I think, there were a whole slew of savings and loan failures, many of them centered, for example, in Texas. A number of them were also centered in New England. And there were a couple of what they call bank fraud task force that was set up. One in Texas, one in New England, that was geared to prosecuting and examining just those cases. We have opioid task force now that are usually composed of representatives of regional representatives of various U.S. attorneys' offices, and those work pretty well. The idea is to provide special training and focus to a group of experienced prosecutors who will kind of in a laser beam fashion focus on a particular problem. And that's what you're seeing with the PPE, which is, government is giving out billions, trillions of dollars. And we know if you follow the money, there's going to be some fraud. And so why not get ahead of it, which the department has done, and set up some task force to examine where the money is going.
I'd like to turn now to the structure within the individual U.S. Attorney's Office. And once again, looking to your experience, Did the attorneys under you, were they assigned cases? Did they bring cases to you or their supervisors for consideration? How does that work within an individual office?
Yeah, it varies. And, in some offices, the larger offices, and I'll say that typically deal with more complex cases. It may vary from office to office, but at least in my experience, there were some cases that I probably never saw. Use my bank robbery example again. If there was an individual, bank robbery in Boston, Revere, Worcester, wherever it was, and that was being investigated by the FBI, that would go to what we call the major crime unit. I probably wouldn't see that. That would be approved by the chief of the major crimes unit, and then approved typically by the chief of the criminal division in my office. And I may never see that one. On the other hand, if it was a case involving some complexity or some sensitivity, that would kind of go up the chain. It would go up from the unit chief. Let's say if it was an organized crime case, it would go up from from what we call the strike force to the criminal chief to the first assistant, and then I would look at it and examine the matter, and typically meet with on an ongoing basis with the AUSAs who are on the front line in the case before authorizing a prosecution. So it varies from office to office and from case to case. There are some particular cases that require, this is again all set forth in the U.S. Attorney's Manual, will require the approval of the U.S. Attorney's Office, and in some cases require the approval of the particular litigating division in the Department of Justice. So sometimes the approval process does not stop at the U.S. Attorney's Office. It requires approval by a supervisor in Washington.
Well, Don, unfortunately, we are near the end of our time for this episode, but I wanted to thank you. I think you've maybe thrown back the veil a little bit on what many of us who've been traditionally on the civil side of things, or at least practiced in state court, really didn't understand. So thank you again. I look forward to continuing the conversation.
I'm glad to do it, Tom.
Hello, everyone. This is Tom Fox again. I'd like to thank you for listening to this episode of the FCPA Compliance Report. I'm pleased to announce that the latest podcast series in the Compliance Podcast Network, the Wirecard Saga, has premiered. Originally, it was on the FCPA Compliance Report, but due to its popularity, I have rolled it into its own podcast series. Subscribe to it on the Compliance Podcast Network. It will be out on iTunes the first week in December, so subscribe to the iTunes version of the Wirecard Saga. We're going to take this as long as we can. I know you'll enjoy it. The FCPA Compliance Report is a production of the Compliance Podcast Network and a proud member of C-Suite Radio.